to today's session on property matters, brought to you by Ascent Realty, as supported by Ascent Radio. My name is Destiny Unuati Ijebo. So as we usually do, we'll be discussing some issues, some topics that usually relates to property, and today we are going to be focusing on a particular topic on this session. So our topic for today is property management. Know your regulatory laws. Now, you know we have been doing series on property management. So today we'll be focusing on regulatory laws when it comes to property management. There are so many laws that apply to property management. Some apply directly, while some others apply indirectly. So whichever way, all of these laws, they apply to property management. So we will not be taking all of them because they are quite enormous. So we are going to be looking at some of it, then we'll discuss them briefly, and maybe subsequently we'll get to know more about it. So as we usually do, we usually start by telling a very short story. Today the story we have goes to us. After successfully launching his property management company, Mr. Fisayo Osemegbe has hinted his friend that, okay, you have set up your company, there are some laws that apply to your operation as a property management company. Now his friend is now wondering, after I have gone through all this registration process, why do I need to also focus on other areas again? Is that not enough that I have registered my company and I have set up my staff, I have a well-structured company? What else do I need to bother myself about again? So today we are going to be looking at some of these laws that apply to this company that this man has successfully set up. Is it going to just be operating like that without having recourse to any laws? Are there laws that determines to what extent he can act? So that's what we'll be looking at today. So the first there is the Constitution of the Federal Republic of Nigeria, 1999. Now, how does this constitution apply? Now, the constitution states that every person, every Nigerian citizen is entitled or has the right to own a landed property in any part of the federation. Specifically, it mentions that every Nigerian citizen has the right to own both movable and immovable property within Nigeria. So it doesn't mean that, okay, because I am from Lagos State, I can't own property in Kano State. No, this law is saying that you can own property in anywhere. So nobody can say, okay, because this person is not an indigent of this place, we cannot allow him to own land. No, this constitution is saying you can own land in any part of the country. Now, it is only when the person owns the land, and that is when you can come in as a manager. Now, you also know that if a person does not have any right over a property, you cannot come in to manage that property. And also, as a property manager, you also need to know that, okay, is this person the actual owner of the property before you can begin to say, oh, I want to manage this property for you. So it will be bad for you as a property manager who is a professional to end up giving out a property to a prospective tenant, and later you find out that this person does not actually have rights to own that, or does not have rights over that particular property which you have given out. And by that time, it will be difficult for you to now explain to that person who is a tenant that, I'm sorry, my client is not the owner of this property. So is this constitution that gives that life to ownership of property by any person in Nigeria. This does not mean a foreigner cannot own property as well. There are some specific requirements to the extent to which a foreigner can own a property. We have discussed about that in previous sessions. We may also look at that in subsequent sessions as well, how foreigners can own property as well. Now, if you can own a property in any part of the federation, it means as a property manager as well, you can also manage a property in any part of the federation. No one will say because your company is registered in Lagos State, you cannot manage a property that is in Ogun State or in Kano State. As long as you have the license to operate in Nigeria, you can operate in any part of the country. However, there may be some local requirements for you to operate within a particular place, just like Lagos State that has real estate law that requires you to pass through certain procedure before you can operate in Lagos State as a realtor. So that there may be some other requirements in such states. You also need to comply with that in order for you to act properly with regards to the provisions of the law. Another one we'll be looking at under law that applies to property management is Land Use Act. Now, the Land Use Act is the mother of all laws that concerns property ownership. Now, we have discussed the Constitution, which gives right to every person to own a property in any part of the Federation. Now, the Land Use Act particularly vested all the lands in Nigeria in the governors of the various states. Now, what this means is the governor of Lagos State, for instance, has that right to all the lands in the state. Now, it doesn't mean that he owns them absolutely, but he's holding it in trust for the benefit of all persons in the state. Now, the purpose of this law is to ensure that everyone has access to land, not like certain persons who say, okay, because we are the indigenous of this state, we are going to use this land for whatever purpose we want. We will not allow any other person to enter into the land. That's why the government comes in to acquire a certain portion of a particular community's land for public use. It allows other persons, maybe from other states or from other parts of the same state, to have access to land. Now, if you look at it very well, you find out that almost all the lands in the states are owned by different persons. Now, if this is the case, it means other persons, maybe those who were not born as at the time the persons acquired the land, you have no land to call their own. Now, this Land Use Act vested the land in the state in the governor who is it in trust for the benefit of all the indigenes of the state. Now, how does this apply? Now, this Land Use Act also states the procedure to acquisition and transfer of title. Now, if the procedure that is laid out in a Land Use Act is not properly followed, maybe you decide to let me follow it to the extent to which is convenient, it means therefore you will not be able to act at the best interest of your client. Remember, as a property manager, you are not just acting in the best interest of your client, which is that is the property owner. You are also acting in the best interest of the tenant. So you are a middleman. You are acting on behalf of the property owner. You are also acting in the interest of the tenant. So you must ensure that, okay, this person that I'm going to manage his property has complied with all the legal requirements in accordance with the provisions of the Land Use Act. Now, if the Land Use Act has stated, okay, before you can acquire a land, this is the procedure you must take. Therefore, you must ensure that your client has duly followed the procedure to avoid any issues when you want to bring in new tenants. For instance, for persons who acquire lands that the title were not perfected and issues arose, but the person who believes he has absolute right to the property decides to give you to manage a property, you, without knowing, you gave it out to tenants, and when they get to court, they are going to evict the tenant, and you will be the one the tenant will call first before going to the landlord or the owner of the property. So you must ensure also that the Land Use Act is duly complied with when you want to manage a property. Now, that one we'll be looking at is Statute of Fraud. Now, this law provides that when it comes to property transaction or anything that relates to property or land, you must ensure that everything is in writing. So this also relates to tenancy as well. Although there are exceptions where persons are allowed to do transactions orally, but where a party decides to say, okay, because this transaction wasn't done orally, they can easily deny it was done orally. If any transaction is done orally, parties can easily deny. But when it is reduced into writing, it's difficult because you say fast speak for itself. So you must ensure that any transaction you are doing that relates to land has to be reduced to writing. No matter how trustworthy the other party may seem to be, whether it's the property owner or the tenant that is coming in, this law provides that you must ensure that everything that relates to that land is reduced to writing. When you fail to do that, every of the transaction you must have spent your time and resources conducting will be void. So it's best you follow this particular law that requires you to reduce property transaction into writing. Now, another one you also want to consider is land registration law. Now, what does this have to do with you? Now, generally, the law provides for the registration of titles to land in Lagos State. So, because we are situated in Lagos, we are focusing on Lagos. It aligns the procedure to conduct searches on landed properties within the state. Now, as a property manager, it is important for you to also do your own due diligence on a property you are managing. It is not enough for you to sit in your office, the property owner comes, gives you a property to manage. Oh, Mr. Osemegbe, I have a property located at Ikeja and I want you to manage. You just go there because you are enthusiastic about getting new clients, without doing background check on the property and the property owner. So this land registration law tells you, okay, this is how you are to go about it. This is the place you have to go to do a search when you are trying to verify the title of the property owner. Property owner tells you, okay, manage this property for me and be sending money to this particular account. Because there are so many dubious persons who go about every place giving a property that are not theirs. If someone can sell a property that does not belong to him, what about rent? They can easily do that as well. So you must ensure the person that is giving you a property actually has title to the property he or she is giving to you to manage. And this registration of titles law tells you this is how you have to go about the search, and this is the place you have to search, and this is the thing you should look out for when you eventually get the search report. So when it tells you, okay, this is what you should look out for to know if actually this person who has said, I own this property, actually own it. So that's one thing you also need to be sure of. Then another law you also need to look at is the land use charge law of Lagos State. Now this law regulates the rates payable to the Lagos State government on landed properties within the state. Now there are rents that you are to pay on certain properties. It depends on the value of the property, location, and every other thing that may be considered. Now it is only when you know about this law that you will be able to advise both your clients, the property owner, and the tenant that is coming on board. Now, ordinarily, the person that pays this charge, the rate that is on the property, is the property owner. However, where the property is going to be leased for a period exceeding 10 years, the property owner may not be liable to pay for land use charge, but the tenant will be required to pay same. So it's like the person who is the tenant has rights over the property over a very long period of time. Now, since the person is the one enjoying the property and everything that is in the property, he should also be able to pay the charges that come on the property. Now, as a property manager, if you do not have knowledge of this law and a prospective tenant comes and tells you, okay, I want to lease this property for a period of 15 years, and the property owner has agreed to lease the property, when it comes to the time where you need to pay this charge and the tenant is given the bill, the tenant will say, I wasn't told that I need to pay this. I have paid for the term that the property was leased to me. I am not going to pay any other thing except for utility bills. Now, it is when you know about this law that you're able to advise the client, okay, this is what you will pay if you are going to be in the possession of this property for this certain period. But if you are going to be in this property for, let's say, a period of 1 to 9 years, the landlord or the property owner will be the one to pay for the land use charge. But if you are going to be in the property for a period exceeding 10 years, or 10 years as the case may be, you'll be the one to pay these charges on the property. Now, it is when you have advised these prospective tenants, he'll be in better position to make a decision for himself. You will not be the one to make the choice for him, but you give him the positions of the law. Okay, this is what's obtainable, and he'll be able to make a choice. If he decides to go on by entering the lease agreement, it means he'll be the one to pay the rates that we put on the property. Now, under law that applies to property management, it may not seem to be a very direct application. However, it applies in some way, because you need to advise your clients when they are also acquiring new property. Now, this is Nigerian Urban and Regional Planning Act. Now, you know that certain properties or certain locations are designated for a particular use. There are places that are designated as central business district. You see all of these names when you are going around town. Okay, these places have been assigned. Okay, we are going to use this place for industrial purpose. We are using this other place for residential purpose, and for different purposes which they designate land. Now, this law empowers the state to determine what should be for a certain purpose and where should be allocated for a certain purpose. Now, if as a property manager your client has told you, okay, I want to expand my business as a private developer and I want to go to a certain area, it's your knowledge of this law that will help you to advise him. Okay, you want to acquire a property in a business district. Okay, can you build residential property there? When you also want to get industrial property, are you going to allow your client to build in a residential location? So it is when you have knowledge of this law that you know, okay, this is what is expected of a person who wants to acquire a property. If you are acquiring a property in an industrial area, it means whatever you are going to do with the property must be centered around industrial use. Now, if you are acquiring a property in residential area, it means your aim of acquiring the property is for residential use only. So it's this idea of this law that will help you to advise your clients very well. Now, the other one you also need to look at that applies to you particularly as a property manager is Rent Control and Recovery of Premises Act. Now, this act provides, okay, this is what you must do when you are getting in a new tenant, and if you want to evict a tenant, this is what is also required of you. It lays down the procedure to be followed when bringing in a new tenant, how the relationship between the property manager, the property owner, how it should be going at every point in time. It states the powers that the property manager can exercise, the property owner can exercise, and the rights of the tenants as well. So it's not enough for you to say, okay, because I'm a property owner, I can do whatever I want because I have authority from the property owner. No, this law tells you to the extent to which you can act as a property owner. It also tells the tenant, okay, these are my rights. Whenever someone infringes on it, I can always seek redress. You can either go to court or you try to settle amicably. Where you fail to settle, that's when you proceed to court. Now, if you do not have knowledge of this Rent Control and Recovery of Premises Act, you are likely to take laws into your hands. Because most persons, they believe, okay, because the judicial system is not very fast, let me do it in another way. No, it is not permissible by this law. You must follow the procedure laid out. Even when the tenant is stubborn, you must follow the procedure that is laid out for recovery of premises. Now, another thing you also need to look at under law is the Stamp Duty Act. Now, this act regulates the sum payable as tax to the government of the state upon purchase of new property. Hence, when a client purchases a new property, you have a duty to inquire if stamp duties have been paid. Now, you want to go into management of a property. There are certain information you need to get from the property owner, so as not to have issues when you take control of the property. If there are debts that are left to be paid, is it the tenant that is coming into the property that is going to pay those debts, those duties that the property owner ought to have paid? If you fail to pay those duties because the person feels I can always dodge the law, you can see that when you go around the city, you see places that are, you see the sign sealed. So it's failure to comply with this act that has made so many properties to be sealed within and outside of the state. So as a property manager, you must ensure that your client complies with the Stamp Duty Act. All the duties that are on the property that he has just acquired are duly paid for. So you don't have to run into any issues with your tenant when the property is eventually sealed because the landlord failed to pay the duties on the property. Another one we also need to look at is the Tenancy Law of Lagos State 2011. So this applies to issues related to tenancy within the states. So if you have any issues that borders on tenancy as a property manager, you also need to make reference to this law as well. Now this law applies particularly to Lagos State. You must ensure that, okay, the due process is followed. Like I said earlier when I was talking about the rent control, this law also provides the procedure you must follow. What are the notices you are required to give to a tenant? What is the length of the notice? If the tenant remains in the property after you have given the necessary notice, what is the next step to take? And if there is any delay, what are you required to do in order to get back your property? And if the tenant eventually is evicted from the property, what other step are you expected to take in order for you to recover whatever sum the tenant has owed, either in rent arrears or the means profit? So this law states the procedure and how you must go about them. If you decide to go outside of it because you're in a hurry to get your property back, you end up running foul of the law and you'll be liable to pay damages to the tenant. You will find out that whatever you wanted to recover from the tenant, you pay excess of it when the matter eventually gets to court. So you must ensure you have clear knowledge of the provisions of this law in order not to run foul of it at any point in time. Now, that one we'll quickly look at is Capital Gains Act. Now, your client has acquired a property because you are his manager. You decide to tell him, okay, I think you need to renovate this property. He has indeed decided to renovate the property. After renovation, he now felt, okay, the value of this property has increased. I think I need to sell it off because there is another project I need to carry on in another place. Now, if this is the case, assuming the property owner bought the property for the sum of 100 million, and after renovation on your advice, he spent 50 million, and the value of the property now, or what he has spent entirely, now amounted to 150 million. Now, the property owner has found persons who have shown interest to buy the property. They have bidded different amounts and decided to settle for the sum of 200 million. That means he has now made a profit of 50 million. So he's going to pay a tax on that amount, which is now the profit. So Capital Gains Act relates to the profit you make on a property that you have sold or you purchased earlier as a lower amount. The value has increased because you renovated the property. Earlier the value was 100 million, but because you renovated the property, you have now gotten the value to now be 200 million. As you have sold it 200 million, you now have a profit of 50 million. You are not paying any tax on the sum of 150 million which you spent, but you are paying tax on the 50 million which is the profit you have made on the property. So that's that for the Capital Gains Act. So in summary, as a property manager, you need to look at all of these laws and see how they apply to each step you are taking. Now there is different stages. There are different stages when you are managing a property, and there are ways that these laws apply independently and collectively. So you must ensure you have knowledge of each one of them. You don't need to have very thorough knowledge, but when you have a bit of each of them, it guides you on what to do. And whenever you are having issues, you get to ask questions, ask lawyers questions, consult lawyers, so that they will be able to advise you because they are more vast in all of these laws. So you'll be able to advise, okay, this is the next step you should take. And if you are already on a track that is wrong, they can always help you to retrace your steps in order to let your actions align with the provisions of the law. This is how far we can go today. Next week we will continue on this same line of discussion where we discuss other laws that apply to your property management, whether directly or indirectly. We'll be discussing that subsequently. So we encourage you to follow us on all our social media platforms, and you'll get notification whenever we go live. Turn on the notification bell so that you always follow us live. Thank you once again for being part of this session.